meetings. So what you're supposed to be able to understand under this particular topic, you're supposed to understand the rule in Sharpe versus Dawes. The rule in Sharpe versus Dawes. You're supposed also to be able to understand and its exceptions. You're supposed also to be able to understand importance of meetings in a company, importance of meetings in a company. Then you're supposed also to be able to understand the requisites, or sometimes they say the essentials of a valid meeting in a company, essentials, requisites or essentials of a valid meeting in a company. Also be able to understand the types of meetings in a company, Then lastly, just be able to know what are the resolutions or type of resolutions that can be passed at company meetings. Here there are two key ones, the ones we are calling a special resolution and what we call an ordinary resolution, So this is what you're supposed to be able to understand under the topic of meetings, which is topic number 7. So when you talk about carrying out business in a company, then of course, business can be smoothly run in a company by people being able to come together and maybe deliberate on the matters concerning the company. Not everything will just go on without trying to be able to come together as those who are within the company or those who have an interest in the company, like the stakeholders or maybe creditors or maybe shareholders of the company. So they must actually be able to come together and be able to maybe discuss matters that are actually concerning or affecting the company. So a meeting is just an assembly of people discussing a matter that could actually be concerning them as members of that particular maybe association or those who have the same interests. If they meet and actually make discussions concerning them, then we can actually be able to conclude that they're actually doing or carrying out what we call a meeting. So under this particular rule in Sharpe versus Dawes, this rule simply basically tries to explain or define what is actually a meeting in a company. So the rule in Sharpe versus Dawes simply states that a properly convened meeting in a company can actually only be held by 2 or more persons, or a properly convened meeting in a company will have taken place if 2 or more people within the company are actually able to assemble. So it simply states that a properly convened meeting in a company must be held by 2 or more persons. A properly convened meeting in a company must be held by 2 or must be held by an assembly of 2 or more persons. If it is less than 2, then that one is not a properly convened meeting in a company. So that is what that rule actually states, that a properly convened meeting in a company will basically be held by an assembly of 2 or more persons. If it is 1 person, then that will be taken under this particular rule as not being a properly convened meeting. So any meeting in a company under the rule of Sharpe versus Dawes, basically the requirement is that the meeting must be held by 2 or more persons. But of course, most recently or under certain circumstances, it is not always that a meeting will actually be held by 2 or more persons. 1 person can actually be able to constitute a meeting in a company and pass what we are calling resolutions. Because at the end of the day, in a company meeting, basically what will come out at the end is what we call resolutions. Those decisions that are normally made will actually be termed as being resolutions. So a properly convened meeting in a company can only be held by 2 or more persons. So that's what this particular rule actually states. But of course, you are saying under certain circumstances, this rule is not actually true, and they're actually what we call exceptions. Under exceptional circumstances, a single person in a company can actually be able to pass a resolution. Basically, you can simply just conclude it's like he has held a meeting and he has actually basically passed a resolution. So that is what that rule actually states. So what I want us to look at is what are these exceptions? Under what exceptional circumstances can you find that in a company a resolution has actually basically been approved or passed by 1 person? one of the circumstances under which one person can constitute a meeting and pass a resolution in a company is, for example, in the case where a meeting has been convened by the order of the registrar. So in case a meeting is actually convened, where a meeting is convened by the order of the registrar. So that could be an exceptional circumstance where only one person can be able to attend, and it will be presumed that this person has formed a proper quorum to be able to carry on the business of the company or pass a resolution. So that one is actually an exception under the rule in Sharpe versus Dawes. If the meeting is convened by the order of the registrar and only one person is actually able to attend, it will be concluded that the meeting has actually been properly convened. Number two, if a meeting is convened by the order of the courts, if the meeting is convened by the order of the courts, if a meeting is actually convened by the order of the courts, then in such a case, if only one person actually attends, because maybe the reason as to why the court has given the order for the meeting to be held, maybe some of the members of the company are deliberately absenting themselves so that the business of the company cannot actually basically be concluded or be carried out. So in such a case, if one of the shareholders actually goes to the court to bring a complaint that a meeting has actually always been called, but some of the members or shareholders are not actually able to attend, or they are basically just doing it intentionally not to attend, he can go to the court and the court will simply give an order for a meeting to be held in the company. If only one person actually attends, that meeting will basically be concluded as actually having been properly convened. So in such a case, that one is actually an exception under the rule in Sharpe versus Dawes. Than the rule in Sharpe versus Dawes. Number three, another scenario is where we have what we call, when we'll be looking at the types of meetings, we'll see, for example, we have like a meeting like an AGM, we have a meeting like a general meeting, we have a meeting like a class meeting, we have a meeting like another one known as creditors meeting. So for example, if it is a class meeting and the shares in that class are actually held by one person, that person will properly basically, it will be concluded that he can actually be able to form a quorum for the class meeting. When I talk about a class meeting, I simply mean it is a meeting of holders of a class of shares. When I talk about a class of shares, then just remember what we learned about the classes of shares. We can have, for example, preference shares. We can have, for example, ordinary shares. We can have, for example, redeemable preference shares. We can have, for example, employee shares. We can have, for example, founders shares. So in that case, if we have preference shares in a company that are actually held by only one person, in that company, only one person has preference shares. If a class meeting is to be called, then in such a case, that class meeting will basically be held by that sole person, because it's the only one in the company who has the preference shares. So if there is a type of a meeting that is to be held in the company known as a class meeting, in such kind of a company, that class meeting will only be held by one person. So that's another exceptional circumstance under which a meeting can actually be presumed to have been properly convened in a company by only one person. So if we have a class meeting, so number three, we are saying if we have a class meeting where the shares in the class are held by a sole person, The shares are actually held by a sole person. Then in such a case, it simply means that that class meeting will actually be held by the sole shareholder who has all the shares in that class, So that's another exceptional circumstance. So another one, which is number four, for the case of a private company, if you can actually remember well, we said that under the types of companies, that a private company, its membership is actually 1 up to 50. So if you have a board meeting of directors, of a private company. So in the case of a private company, a board meeting being held, a board meeting being held by the sole director and shareholder, the sole director and shareholder, the sole director and shareholder. In this case, what we mean, for example, James has actually formed a private company. And in such a case, James is the sole owner of the company. James is the sole director of the company. Will James go outside to call Neddy to come in and actually they hold a meeting? Yet Neddy is not even a member of the company. No, James will simply basically pass resolutions regarding the company on his own as a sole member and as a sole director of a company. So in such a case, you can see this circumstance is making it basically to come up with an exception under this rule by Sharpe, whereby it basically states 2 or more persons can only be able to hold a meeting in a company and pass a resolution. So in the case of a private company where we have only one member and who is actually the sole director, in such a case, all the decisions or resolutions of the company will simply be passed by that sole director, So in such a case, that is actually another exception. Number 5, at an adjourned meeting, where the meeting is only attended by a sole member, where the meeting is attended by one person. So at a postponed meeting, at an adjourned meeting where the meeting is attended by one person. So for example, they could postpone a meeting in a company. After the postponement, only one person is actually able to attend. In such a case, it can actually be presumed that person has formed a quorum to be able to pass a resolution. So in such a case, this one just tries to avoid circumstances under which, or scenarios whereby when they call for a meeting, people deliberately absent themselves. So you can't keep on postponing like that. To avoid that, basically, if they have postponed a meeting and there's no genuine reason for the other members not to be able to come, then if a sole person is actually able to attend, it will be presumed that he is actually able to form a quorum. He's actually able to form a quorum in such a case. The last one, another type of meeting which I haven't mentioned here, maybe it is like creditors meeting. So for example, if the creditors of the company, you find that all the liabilities of the company in terms of creditors is actually only one person. If we have to have what we call a creditors meeting in the company, that meeting will actually simply be held by that sole creditor. So if the company has only one creditor and the company is to have a creditors meeting, in such a case, it is only the sole creditor who will basically be able to approve any matter concerning him as the creditor of the company. So a creditors meeting where the company has only one creditor. A creditors meeting where the company has only one creditor. That is another exception under the rule in Sharpe versus Dawes. Under the rule in Sharpe versus Dawes, whereby we have creditors in the company, but those creditors, it is only one person. They are not more than 2. The company has only one creditor. If the company is to hold a creditors meeting, in such a case, that meeting will basically be held by that sole person. So those are some of the exceptions under this particular rule known as Sharpe versus Dawes. It does not prevail always, and of course, there are actually exceptions to the rule. There are actually exceptions to the rule. So that is what I mean by the rule in Sharpe versus Dawes and its exceptions. So it is a very common area in the exam. It's something you must never forget. Never forget about it. It should actually just be on your mind. Just be on your mind. What are the exceptions? Because they really like testing it. So I think it's one of the major rules we've come across. For example, the most recent one that we came across, I think it is the rule in Trevor versus Whitworth. That one that simply states that a company cannot purchase or finance the purchase of its own shares, and it has its own exceptions. So you must actually be able to be going through them. I know some of you have forgotten some of them, but the most recent one we've learned before this one, it is the rule in Trevor versus Whitworth, which simply states a company cannot purchase or finance the purchase of its own shares. And of course, we saw some of the exceptions under which a company can actually be able to purchase or finance the purchase of its own shares. For example, we said in the case where the ordinary business of the company is to give out loans, In such a case, it can simply finance someone and it basically buys the shares of the company. A situation whereby the company gives out dividends and you as a member, you decide to buy the shares of the company with the dividends, it's like they have financed you to buy the shares. So that is an exception whereby someone can actually be financed by the company to buy its own shares. If we have an employee scheme where the company gives out money to the employees, and this money is basically utilized to buy the shares of the company, that one is like financing the purchase of the shares. Another one whereby the company can actually be able to finance is, for example, if they give out a loan to an employee. Remember, there's a scheme. A scheme is an employment scheme of a company whereby they, for example, they have their own benefits. Under these benefits, now they give out money, or they give you money as an employee to buy the shares of the company, or they finance the purchase of the shares of the company by giving you money. So that is an exception. Alternatively, there could be a loan that you are given by the company. You are given by the company a loan. You utilize that loan as an employee to buy the shares of the company. So that is an exception whereby now the company can actually be able to also finance. So there are exceptions actually also under direct purchase. And I told you to be very keen, because sometimes the examiner could basically ask you to state exceptions under directly financing, not actually directly purchasing. So if you're able to know the difference between the two, it is better. Directly purchasing is whereby they don't give another person the money, they just directly purchase. Because under direct purchase, we said, for example, under forfeiture of shares, under a valid share capital reduction, could be an exception, under a valid surrender of shares by a member, through a court order, the company is actually forced to purchase shares of an oppressed minority. That one could actually also be an exception under direct purchase. It is good you remember some of those rules and the exceptions. So why is it important for the company to hold meetings? For importance of meetings in a company. What is the importance of meetings in a company? So the meetings are actually important because some of them are actually a statutory requirement that they be held by the company. So once the company holds them, it is meeting the requirements under the law for holding the meetings. So for example, it is a requirement by under the Companies Act. The company must actually always hold an annual general meeting once each and every year. So the holding of some of these meetings in a company is to meet the requirements under the law, under the law. Another reason why it is important to hold meetings, it is because the company will actually be able to deliberate on matters that can actually only be deliberated at some of the types of meetings. For example, there are only a few matters that can only be deliberated at an annual general meeting. So the company will actually be able to approve matters concerning, or basically they're supposed to be approved at an annual general meeting as per the requirements of the statute. So number one, you've said some of the meetings are requirements under the statute to be held. So once the company holds them, it will be meeting those requirements under the law. Then number two, you are saying to be able to deliberate on matters or discuss matters that can actually only be approved at like an annual general meeting of the company. Like for example, approval of dividends, for example, appointment of directors of the company, for example, appointment of auditors of the company. So to approve matters that can actually only be approved at an annual general meeting. Another reason is to basically just to deliberate on matters affecting the company, on how the company should actually be able to progress in terms of management, in terms of operations, any matter concerning the company that basically leads to maybe the prosperity of the company, then it will likely be discussed at the meetings of the company to discuss any matters affecting or concerning the company. Then to be able to discuss matters affecting a class of shares, that one will be discussed at a class meeting. So maybe variation of class rights. They want to vary the rights of a class of shares like preference shares. That one can actually only be approved. At a class meeting of the company, So those are some of the importance or reasons as to why the company basically have to hold what we are calling meetings, to hold what we are calling a meeting. So sometimes they could ask you what are the importance of meetings. Just remember that you said it is a requirement under the law for some of the meetings to be held. Number two, to discuss matters or deliberate on matters that can actually only be discussed at an annual general meeting. To maybe deliberate on matters affecting the company in terms of operations or how the company is supposed to be run. It is important the meeting be held so that they can discuss such. To discuss matters affecting a class of shares, for example, variation of class rights. Variation of class rights. If the company wants to vary the class rights, then of course they'll likely be able to discuss those matters or approve those matters at a class meeting of the company, at a class meeting of the company, at a class meeting of the company. So I want us to look at the requisites or essentials of a valid meeting in a company. What are the characteristics that are basically the requirements that must actually be met before it can actually be concluded that there has actually been a valid meeting that has been held in the company? So there are 5 key ones. There are 5 key ones, essentials. So there are 5 key essentials. So number one, the meeting must be convened. The meeting must be convened by the proper authority, by the proper authority. So the meeting must be convened by a proper notice, by a proper notice, a proper notice, by a proper notice. Then there must be a quorum. There must be a quorum for the meeting, a quorum for the meeting. There must be a quorum for the meeting. Number 4, minutes must be kept. Minutes must be kept, recorded. Minutes must be kept or recorded. Kept or recorded. Then the last one, which is number 5, there must be a proper person as the chair of the meeting. There must be a proper person as the chair of the meeting, as the chair of the meeting. So these are key 5 essentials that must be there for it to be concluded that there has been a properly convened meeting in a company. So the meeting must be convened by the proper authority. That person who has the authority in the company is the one who's supposed to call for the meeting. The meeting will be called by a notice. There must be a notice it is going to be sent out. There must be a notice that will actually be sent out. There must be a notice that will actually be sent out. That must be sent out to maybe the members. There must be a quorum. There must be a quorum. For example, if they have to pass a special resolution, at least 75% of the members must actually be in attendance to be able to approve such kind of a special resolution. Minutes have to be taken. In each and every meeting, you know, of course, you'll hear there is a secretary who's supposed to take the minutes. So the same case in a company, minutes have to be taken. There must be a chairman. In each and every meeting, you'll see people saying who is the chairman, who is chairing the meeting, like that. So there must be a proper person as the chair of the meeting. When you talk about convened by the proper authority to convene a meeting in a company is actually the board of directors of the company. But under exceptional circumstances, for example, if they have failed to call for a meeting, then of course, members of the company can actually be able to take that particular step and find ways on how they can actually be able to call for a meeting. For example, if the directors have failed to call for an annual general meeting for a number of years without any reason, because you are saying in each and every company, the AGM must actually be held annually. And you are saying the proper authority to convene a meeting are actually the board of directors. So if they fail to do so, then of course members can actually be able to take this particular step in their hands. How do they do it? So holders of at least a 10th of the issued share capital can actually be able to petition or ask the court to give an order for a meeting to be held in the company. So if the directors fail to do so, who are the proper persons to convene a meeting, members can actually be able to go to the courts and maybe ask the court to convene or actually call for the meeting. Then we are saying a notice will actually be sent out. So the content, you need to be able to know what will be part of the content of this particular notice. It will basically indicate the date and time of the meeting, when will actually the meeting be held, the venue of the meeting, where will actually the meeting, where will be the meeting. It will indicate the agenda of the meeting. It will be part of the contents of the notice. So we are saying it will indicate where exactly the meeting will actually be held, the time the meeting will actually be held, what will be the agenda at that particular meeting, what will be the agenda at that particular meeting. It will actually also indicate who is convening or who is actually calling for the meeting. Who is calling for the meeting? Is it the chairman of the board? Is it the board as a whole that is actually convening the meeting? So it will indicate down there on the notice, maybe being signed by the secretary of the board, that this is the authority that is calling for the meeting. So those will be part of the contents of the notice. Then if it's an annual general meeting then or a general meeting, so the notice should actually be sent out at least 21 days before the meeting, so that the members are actually given time to prepare themselves for the meeting. So they must get at least a 21-day notice before the meeting is actually held. So that is a requirement under the statute, that the meeting will actually be convened and they'll be given a period of at least 21 days to prepare themselves before the meeting can actually be held. So there'll be a 21-day notice if an AGM is to be held in the company. Then quorum should actually be there. So before the meeting is actually held, there must actually be a quorum. If a special resolution is going to be passed, then quorum must actually be there. At least 75% of the members of the company must actually be in attendance. So the chairman before, or the person who is known as the chairman, before the meeting actually commences, he must actually be able to satisfy himself that there is actually a proper quorum for holding of the meeting. If there's no proper quorum, then of course we'll see under the powers of the chairman, he can actually be able to adjourn or call off the meeting to maybe until next week or the other week, the same time. So the chairman should actually satisfy himself that there is actually a proper quorum for the meeting. So those members who are not actually able to attend will basically seek to be represented by a person known as a proxy. A proxy. So a proxy is simply a person who can actually be able to represent you in a company meeting as a member if you are not actually able to attend. So how will he get that authority to attend the meeting on your behalf as a proxy? When the company is sending out the notice for the meeting, they'll send out with what we call a proxy form. A proxy form. This proxy form will basically give you the mandate as a member of a company. You will actually be able to fill it. You'll fill that particular proxy form and indicate, I won't actually be able to attend, but I've given this particular person the mandate to attend the meeting on my behalf. So you'll become your proxy. So you must actually be able to give back this particular proxy form back to the company in time before the meeting is actually held, so that they can actually be able to know that these particular members won't actually be able to attend and they are being represented by a person known as a proxy. So when the notice is being sent out, they'll send out with a proxy form. The proxy form must be filled by the member in case he's not actually able to attend the meeting. So in such a case, he'll indicate the details of who will be actually his or her a proxy to attend the meeting on his or her behalf. So part of the ascertainment of the quorum, they'll ascertain whether the actually proxies who are basically representing those who are not actually able to attend the meeting. So you as a member, you give guidelines to the proxy of how you want maybe for him to be able to vote on your behalf. If there's a matter that is going to be discussed, which has actually been indicated in the notice, what will be actually be discussed, you can simply guide the proxy on which position he can actually be able to take while voting at these meetings, or while actually voting at these meetings. So we are saying minutes must actually be kept or recorded. So minutes must actually be kept or recorded. So the minutes of the meetings that are going to be held in the company should actually be recorded or be kept, and the person who has the responsibility, we'll see later on, is the company secretary. Is the company secretary. Is the company secretary. Is the company secretary. So the company secretary is the one who will likely be able to record the minutes at the meetings of the company. So the contents of these particular minutes are just the normal contents, like for any other minutes. It will basically indicate the date and time and the place where the meeting was actually held. The minutes will actually indicate the persons or the people who are actually present at the meeting. It will indicate those who are actually absent, maybe with apologies. It will indicate those who are just deliberately absent without any apologies. It will indicate the active agendas that have actually been discussed at the meeting. It will basically be signed by maybe the secretary of the meeting and the chairman of the meeting. Just the normal contents of any other minutes that will be the contents of the minutes that will likely be taken at the meetings of the company. The date, time, and place where the meeting was actually held, those present, those absent, agendas actively discussed at the meeting, they'll be signed by the secretary and the chairman of the meeting, the secretary and the chairman of the meeting. Then we are saying there must be a proper person as the chair of the meeting. So before the meeting actually commences, it must actually be ascertained that there is actually the chairman of the meeting who will basically guide on how the meeting will actually be held. So part of his duty is basically for him to be able to ascertain whether there is proper quorum for the meeting. It is one of the duties of the chairman to ascertain that there is proper quorum for the meeting. He'll basically have to ensure that he has basically briefed, for example, informed those in attendance what is the agenda of the meeting, be able to guide the members during maybe voting, how the voting will actually happen during the meetings. He can actually be able to decide on points of order when they're actually raised. For example, if someone has an issue to raise or has a point of order and he has raised the hand, he'll decide who can actually be able to speak in such a circumstance. So to decide on points of order when they're actually raised by the members actually present. So part of his powers will actually, for example, include to eject any members who are causing disturbance during the meeting or violence during the meeting, to eject any person who is not supposed to attend the meeting and is actually in attendance without being authorized to attend. Maybe he's not a member of the company, you can eject such a person. Another power he has is, for example, to postpone or adjourn the meeting if basically circumstances actually are forcing the meeting to be adjourned. So maybe you could be asked, what are the circumstances? So maybe there's no proper quorum, so you can adjourn. Maybe there are certain things have actually arisen which are actually out of hand or cannot actually basically be managed. For example, there's a disaster at a place where the meeting was supposed to be held. So if emergencies actually arise like such, you can actually basically postpone or adjourn the meeting. But of course, this power to adjourn the meeting will actually be derived from those in attendance or members in attendance. So you basically ask them to approve. Once they approve, he will declare that the meeting has actually been postponed or adjourned, has actually been postponed or adjourned. Another power that he has is, for example, he can actually be the tiebreaker in case there's voting and there's a tie. He'll basically be the last person to basically now cast the vote to decide on a matter. So he must actually be able to use it appropriately or use his vote appropriately. He has that power to be able to decide on a matter in case there's a tie in terms of voting. So those will be part of the duties of this person we're actually calling the chairman, the person we're actually calling the chairman, the person we are calling the chairman. So those are the requisites or essentials of a valid meeting, the requisites or essentials of a valid meeting, So just be careful with the duties of the chairman, the powers and duties of the chairman. And I think they are in your notes, the notes I've shared. I think I've shared all the notes up to topic number 14. So you can go through them and be keen with they normally ask very simple questions here, but you need to be very keen. Like the powers and duties of the chairman has been tested. Contents of minutes has been tested. Contents of a notice has been tested. That one has actually also been tested. So you need to be very keen when you discuss such, the contents of a notice. They could ask such kind of a question. They could even ask, what are the contents of minutes of a board of directors meeting? So I've told you the contents are just like any other minutes, how you are taught to write minutes, for example, in English. Minutes for meetings will just be like that. There's no any other format that is appropriate. So those will be just be the contents. For example, in the case of contents for minutes of a board of directors meeting, it will have a date and time where the board meeting was actually held, date and time and place where the board meeting was actually held, directors in attendance, directors who are actually absent, agendas actually discussed at the board meeting, and of course it will actually be signed by the secretary of the board and maybe the chairman of the board and maybe the chairman of the board, the chairman of the board, the chairman of the board. So those are the requisites or essentials of a valid meeting. So I think we started the class late. I don't have a smartphone right now, so I was not actually able to reach to you guys. And no one among you actually reached out to me to find out whether they'd be a class or not. So I was trying to get my colleagues to send you the password, but I think I was not getting them. I even sent one of you an email, so I think she didn't see it. So that's why we started the class late, but you are supposed to start at 11. So I think I'll end there the class and we'll basically take over, pick up from there next time and wind up the class, wind up the topic of meetings and maybe start the topic, which is topic number 8, which is actually directors. So I think we'll meet next time and have a good afternoon.